When you bring a lawsuit against your doctor for medical malpractice, and now your case goes all the way to trial, how does the jury know which experts to believe? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You know that before we can go ahead and actually start your lawsuit, we have to get confirmation from a medical expert who has reviewed all of your records. And the expert has to confirm that, number one, your doctor was careless. Number two, that his carelessness was a cause of your injury. And number three, that your injuries are in fact significant and or permanent. All three of those things have to be present in order for our expert to give us the go-ahead to go ahead and file a lawsuit on your behalf. All right, let's say we have that. And now we go forward with a case on your behalf. The defense turns around and says, "Why are you suing me? We did nothing wrong." And not only do they say they did nothing wrong, they said, "Look, whatever I did didn't cause or contribute to your injuries." And then they say, whatever injuries you have, they're really not as bad as you claim them to be. Which means your case is likely going the distance and going to go to trial. All right, so now as your case progresses to trial, we notify the defense that we have various medical experts to support our particular case. Likewise, the defense lets us know that they have hired medical experts as well to go ahead and defend their case. So now you've got competing experts. So now we know that when we get to trial, the jury will be hearing testimony from our various medical experts, and then they'll be hearing testimony from the defense's medical experts. So if we have competing medical experts, how does the jury know who to believe? You know, it's as if you have a medical problem, and you go to one doctor who says, "You know what, I'm going to do the procedure that way." And then you want to get a second opinion, and the second doctor says, "You know what, I wouldn't do it that way, I'm going to do it that way." Now, which doctor do you listen to? Which one is believable? Which one is credible? And that's exactly what the jury will have to evaluate. They'll have to evaluate which of these experts are believable. Which ones of them, no, that doesn't make sense. Which one of the experts are credible? Are they more believable? Is the plaintiff's expert, the injured patient's experts, more believable than the doctor's experts, the defense's experts? If the answer is yes, then you're well on your way to getting a verdict in your favor. If, however, the defense's medical experts tend to be more credible and more believable, there's a good chance you're going to wind up with a defense verdict and lose your case. So how does the jury really make a decision about which experts they believe? Well, let me ask you a question. When you meet somebody new for the very first time, how do you know that what they are saying is true? I'll tell you how. You get a gut sense feeling about whether or not they're believable. And based upon that information, you will come to a conclusion about whether or not you actually believe what this person is telling you. So now the same thing applies during trial. You'll have multiple experts get on the witness stand to testify, and now the jury has to listen to both of them, or multiple experts. And they have to decide which one of these experts is more believable. I may like this guy, but I may not like that person. And because of that, that may affect and probably will affect the outcome of your particular case. It all has to do with credibility. Who is more believable? So why do I share this with you? I share it with you just to give you an idea of what goes on at a trial in a medical malpractice case where we have competing medical experts that now are giving testimony about whether something was done wrong to cause you harm, or whatever occurred did not cause you significant harm and injury. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.